Good morning. Seems to be a while. It's been a couple months since our last meeting. Welcome, everybody. We can start. Jerry, if you do a roll call.
Mr. DeLonge?
Here.
Mr. Desai?
Here.
Mr. Horian?
Here.
Ms. Tornatori?
Here.
Mr. Lilly?
Yep.
Mr. Monaco?
Yes.
And Mr. Pollard is excused.
Thank you, Sherry. Second item, the minutes from last meeting. I know it's been a while. Everybody able to read it? And do I have a motion to pass those minutes?
Motion to pass the minutes of the January 13th, 2025 meeting.
Second.
Thank you, Sherry. Roll call.
All in favor, say aye.
Aye.
Any opposed? Motion passes.
Thank you. And our first action item, ordinance 2025-05. Gwen? Thank you.
Thank you, Mr. DeLonge.
Good morning, Chair DeLonge, Vice Chair, Planning Board members. Gwen Herstian, City Planner. This agenda item pertains to ordinance number 2025-05, which is a future land use map amendment for a property which was annexed into Daytona Beach Shores April 1st. This action, if an affirmative recommendation is made, is the first step to adding a future land use for this property to the city's future land use map, compatible with its Volusia County future land use and that of the neighborhood, consistent with the neighborhood. All items have been submitted into the record. This property, numerical address 3836 South Atlantic Avenue, and as I stated, it was annexed on April 1st, just recently. Property owners are also the applicants, Samuel Coughing and Janelle Coughing, and Mr. Coughing is here this morning to meet you. He's behind me on the right. The property size is just under 0.2 acres. It's 1.181 acres with South Atlantic Avenue frontage of 75 feet. Its current future land use through Volusia County is urban low intensity, and its proposed future land use is residential low intensity, which is compatible and consistent. Future land use is single-family residential. Background for the point at which we are now, the property has been annexed, but until we take these two steps, the future land use map amendment and the rezoning, the property is not fully able to be processed and treated as a Daytona Beach Shores property. This is an aerial view of the property along South Atlantic. It's a 5,018 square foot single family residence. Here's what it looks like from the street. Although he's definitely cleaned up all of those. I took the picture when somebody was trimming the tree, but it's a nicely kept property, to be sure. Except now our sign is blocking it. The current city future land use, you can see in pink, the square in pink, it says annexation candidate, but it has already been annexed. Basically, it has no current city future land use assigned to it, but through this process, it will be assigned the residential low intensity future land use. This is a summary analysis of the land use change impact, and there are none according to all of the criteria which are specified to be analyzed. As far as comprehensive plan consistency, that has been analyzed and has been met. Public notice requirements have been met. Impact analysis has been completed, and the requisite staff review has been completed. Staff is recommending approval as presented at this time.
Thank you. Any questions? No question for Gwen?
Everyone's cool.
So currently, as a resident, it's not a rental unit, it's a resident home.
If he's nodding behind me, then that is.
I just wanted to check. No questions?
No.
All right, is there a motion to pass ordinance 2025-05 as given?
I move to recommend to the City Commission approval of ordinance 2025-05 as presented.
Second?
Thank you. Sherry, roll call.
All in favor, say aye.
Aye.
Any opposed? Motion passes.
Thank you, Glenn. Now we're going to enter the quasi-judicial hearing. And you want to go ahead and ask the question about ex parte, or do you want me to ask?
Thank you, Chair, I'll take care of that.
Thank you.
This is a quasi-judicial hearing. That means it is not as formal as a trial, but there still are rules of procedure that we must follow. One of those rules is that the board members have to disclose any ex parte communications they've had with anyone about this particular matter. So I'll start at the end and work my way towards me. Any ex parte communications?
No.
All board members have said no. The next thing is anyone who is going to give testimony should be sworn in.
All right. Anyone who's going to give testimony, please stand and raise your right hand. Okay. It's been a couple months. Okay. Oh my gosh, I just blanked.
You swear to tell the truth, the whole truth?
Nothing but the truth, so help you God.
I do.
Thank you.
Okay, Chair?
Thank you.
All procedural matters have been handled. It's all yours.
Great. Thank you very much. Gwen, you can go ahead.
Thank you, Chairman Belange, Vice Chair, Planning Board members. Gwen Herstein, City Planner for the City of Daytona Beach Shores. This is ordinance number 2025-04, and it's a zoning map amendment. If approved, it will assign a zoning designation to 3836 South Atlantic Avenue, consistent with the property's zoning when in Volusia County and compatible with similarly situated properties in the surrounding area. All items have been submitted for the record. Again, property location, 3836 South Atlantic Avenue, has been annexed into the city. The copyings are the property owners and applicants. Property size is still 0.181 acres. Current zoning district for this property is Volusia County R9, Urban Single Family Residential District, and the proposed zoning district, which will be accomplished through this ordinance, is Daytona Beach Shores Residential Single Family, or RSF-2, Urban Single Family Residential Detached District. Current land use is a single family residence. The residence is 5,018 square feet. Again, the background, this is a necessary step which takes place and can only take place after the future land use map amendment is approved. And this would complete the ability to it would complete the process after annexation of including this property fully within the city of Daytona Beach Shores. This is the site location. It's 2.5 miles south of where we are right now, which is about a 6-minute drive. Again, the aerial map showing the property right along South Atlantic Avenue. And the street view. This is the current city zoning, which you can see it doesn't have a current city zoning. And the city zoning, if this ordinance is approved, would be RSF-2. There are 14 criteria, only 9 are on this page, and the remaining are on the next. 14 criteria which must be considered for rezoning, and before rezoning and before requesting rezoning. These 14 criteria have been analyzed and summarized in these slides. All criteria have been met. And again, the property is consistent with the city's comprehensive plan. The public notice requirements have been met, impact analysis has been completed, and the rezoning criteria have been met. Staff is recommending approval as presented.
Thank you very much. Any questions? Any concerns? Any questions? All right. Is there a motion then?
I move to recommend to the City Commission approval of ordinance 2025-4 as presented.
Second the motion.
Thank you. Mary, roll call?
All in favor, say aye.
Aye.
Any opposed? Motion passes.
Thank you. That was good. So, if there's any other comments or concerns, I guess we will move into nominations and elections. Is there any motion for nomination?
I nominate Rick Delange for chairman.
Second.
I guess we have to do a roll call on that, or?
Let's do each one separate. So can we do a roll call on the chair?
Sure.
A first and a second.
Do we want to get a nomination for the vice chair yet, or just we'll finish the chair?
We'll finish the chair, and then
Okay.
we'll do the vice chair.
Okay. Okay. All in favor of Rick Delange as chair, say aye.
Aye.
Any opposed? Okay, that one passes.
Him.
I know.
Congratulations.
His wife.
Thank you, thank you for your blindness support.
Any nominations for vice chair?
Nomination for vice chair?
Oh, a guy. Guy.
Guy, how would you like to?
That guy down there.
I'm the guy.
Anybody else wants to do it?
Do I hear a second for Mr. Desai?
Second.
Does Mr. Desai want to be vice chair?
You didn't ask me that. All right, is there a roll call on that?
All in favor of Mr. Desai as your vice chair, say aye.
Aye.
Any opposed? That passes.
Say no.
Hey, Chuck, we made it.
Maybe.
Thank you.
Thank you.
So officially, do I close the meeting so you can start, or?
I think this is
Training is
yeah, this is
part of
part
it.
of the meeting, so.
Oh, the training is part of the meeting. So I'll turn it over to you for the training.
I'll just jump right in. So with desktop.
Oh.
Okay, so, microphone working? So I think each of you have done this before,
15 years.
many, 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 many times.
I think it's the only one.
Guy's the only one.
Guy and Mr. Monaco.
First for me.
Oh,
So this is really just for their benefit. But with that said, for the benefit of everyone else, I'm going to run through it. This is nothing that you don't already know. This is just something that we're doing our due diligence, and we try to do this at least annually.
You can see behind
So
you.
you can see it.
You can see behind you.
You can see it there, too.
It's actually bigger right there.
Okay, wherever you want.
Wherever you can see better.
I can see that screen, right?
Okay.
Thank you.
Okay, so this is a smaller version of the required training that elected officials and board members have to do annually. And that's more like a 4-hour training.
Okay.
This is going to be, let's take some votes here. Let's take some bets here, and let's see if I can get this done in under 30 minutes.
I gotta get out of here.
I'm
Store has nobody to.
Let's do 20. This is Sunshine Law, public records, voting conflicts, quasi-judicial hearings for local board members. Okay, government in the sunshine. That means Florida's open meeting laws. Basically, that provides the right of the public access to any public meeting. So that means that all meetings that there are official acts taking, or public business is transacted or discussed, should be noticed and open to the public. And it applies to both elected and appointed boards. It applies, and here's the elements, it applies to any meeting between 2 or more board members of the same board when discussing matters that may foreseeably come before the board. So the key for you to understand is of the same board. So that means you can't communicate among yourself outside of a public meeting. So if you see each other at Publix, you can say, hey, how's the family doing? How's the golf game doing? What are you doing this weekend? How are the kids? That's totally fine. If you see each other at Publix, you can't talk about the upcoming zoning variance that's on the agenda. That's a big no-no. But if you see it, yes, sir.
Does that apply to alternates?
That applies to alternates as well.
Just want to make sure.
Considered a member of the board. Now, the statute says member of the same board. So if you see a council or commission member, you can speak to a commission member. Proceed with caution, but you can speak to a commission member about items about city business. So really, this only pertains to amongst yourself. Not only does it include meetings and workshops have to be open to the public, it also includes telephone calls, text messages, emails, written correspondence, and informal discussions. One of the big things we see around the state with our clients is a board member will email all the other board members about it. They'll get a copy of the agenda and they'll shoot out an email to all the board members saying, I don't agree with this, here are my comments on this. It's a big no-no. Do not communicate even by email. Sherry sends out the agenda. What we recommend when our staff communicates with everyone is to BCC all. That way you don't see who else is on the email, and if you do hit reply, you can't reply to everybody else. So there is no crosstalk. So it's not only in person, it's in writing, it's in email, it's in text messages, it's any kind of communication you could possibly have. 3 basic requirements of a public meeting. Must be open to the public. This obviously is open to the public. If you have a meeting inside your house, that's not open to the public. If you have a meeting at a restaurant, that's not open to the public. If you have a meeting in a small boardroom, that's not open to the public. That restricts people's access. Reasonable notice has to be given. The statute doesn't say 7 days, 10 days, 15 days, 2 weeks. It just says reasonable notice. I think in this case it's 7 days. Is that correct? Certain things have statutory notice, like ordinances. Second readings of ordinances for a commission have 10-day notice. But for what you do, it's reasonable notice has to be given. And of course, meeting minutes must be taken and recorded and open to public inspection. Notice there's a difference in minutes and transcripts. Minutes are just general notes. Those are not transcripts. If someone from the public wants to transcribe it, they can contact Sherry, the clerk. Sherry can give them a referral to a court reporter. A court reporter can get the audio and transcribe the meeting. You cannot use staff to be a liaison between each other, so you can't have Sherry or me pass messages to each other. That's also a no. See, I'm burning through this. I'm going fast. I'm trying to get you guys out of here. Can adopt reasonable rules to ensure orderly conduct of the meeting, but the Sunshine Law does not allow you to ban videotaping, tape recording, photography at public meetings. What we see this most often now is First Amendment auditors. Daytona Beach Shores has been hit very hard in the past year and a half with First Amendment auditors, at least 3 or 4 times. And those are the guys that go around with cell phones, go into City Hall, go to the front desk, they film things on the ceiling, they go on the walls, and ultimately the person at the front desk says, "May I help you?" And they say, "No, I don't need your help, thank you. What are you doing? You can't film in here." And then they put the camera on the person, and then it gets confrontational, and then the person says, "You don't have my permission to film me." And the person at the front desk calls the police. The police come. The police do what police do, and it escalates, and the person gets arrested or detained, and then they sue the city, because they have every right under the First Amendment to be in a public space and film even individuals. They could be in here right now and they could film each and every one of you, and they have the right to do that. They could get you in the parking lot with a video camera in your face. It's uncomfortable. It doesn't feel good, but they have every right to do that under the First Amendment. And they make money off of it, and they look for your reaction. So and this is a whole separate training, so I'm not going to get into that, but my only advice there is if you ever are confronted by a First Amendment auditor, don't take the bait. They call you names, they call you stupid, they call you worse than that, they curse at you. Don't take the bait. If they call you corrupt and stupid, say, "Well, thank you, that's very nice of you. Isn't it a beautiful day? It's such a nice day for you to be exercising your First Amendment rights. It's a wonderful country we live in." You know, just say something like that. Just keep walking. What they're looking for is the reaction. There's a group here in Volusia County. They hit the police officers really hard. They go to the 7-Eleven. Poor police officers at his lunch break. He's going in the 7-Eleven. He's buying himself a fountain soda, a hot dog, and a bag of chips. He's walking out of the 7-Eleven. First Amendment auditors in his face. What are the fire protections of the First Amendment of the Constitution of the United States of America? And the poor police officers, just like on his lunch break, number one, if you ask 90 out of 100 lawyers what are the fire protections of the First Amendment of the First Amendment, or the fire protections of the First Amendment, 90 out of 100 of us lawyers couldn't tell you what those fire protections are. Any of you know what fire protections are?
The right to be silent or...
Speech, assembly, petition your government, press, religion. Those are the 5. I'm thinking religion might not be one of those. But see, even lawyers don't know the 5. So how do you think a poor police officer on his lunch break is going to know? So the police officer doesn't respond well to that. The police officer says, "Get out of my face." It gets confrontational. The police officer does what police officers do, and then he says, "Give me your ID." I don't have to give you my ID. Yes, you do. He doesn't. But the police officer, it escalates into an arrest, and the First Amendment auditors always sue. The insurance companies take the case. They always settle. They always write a check for between $10,000 and $30,000. It's an industry.
Thank you.
These guys make lots and lots of money going around suing cities. They also have websites on YouTube. They get paid for YouTube hits. They also sell merchandise on their website. So there is a group of folks, and they go around and they make a lot of money off cities. So don't be victim to any First Amendment auditors. That's mine. I'll step off my soapbox. We do have First Amendment auditor training that we do give. It's more in-depth and more detailed.
But you're under no obligation to answer, correct?
No, you don't.
Exactly. You have under no obligation whatsoever to even address their question.
You don't have to respond. You don't have to engage. And if you do respond, I would recommend kill them with kindness.
Just for the purposes of this training, that applies to at the public hearing as well, with the exception of?
At the public hearing as well. If they are allowed to come up during public comment. Remember, public comment is not public question and answer. Public comment is public comment. you're under no obligation to answer any questions they may pose. If they ask questions, you can refer them to staff and say staff would be happy, if you'd like to meet with them during business hours, they'd be happy to help you if they have a reasonable question. If it's something from outer space, no, staff can't help them. But if it's something legitimate, point them to staff. Otherwise, you're under no obligation to answer them. Now, if they get disruptive, if the First Amendment protects, it doesn't protect all language, it doesn't protect fighting words, it doesn't protect obscenity. By the way, curse words are not obscenity under the law. Obscenity is, it has to be very vile. Like, think of the deepest, darkest things in your mind. That is obscenity under the law, not cursing. They can call you corrupt. They can call you names. That's all protected under the First Amendment. They can, as long as they're within their 3 or 5 minutes, they can say whatever they want, as long as they don't lie, as long as they don't cross the line and get into unprotected speech. And they can't just be disruptive at a meeting. So if they go beyond their 5 minutes, as chair, you can have them removed. That's not against the law. Now, there's not an officer here, but at a commission meeting, there are officers, and people often are asked to kindly leave the building if they're disrupting a public meeting. Try to avoid that, because it's not a good look for the city. It always ends up on the news that the city police officers drag someone out of a public meeting. That's always a bad look. So we try to avoid that escalation. Public meetings, there has to be right to public comment. So every official action you take, there has to be public comment. Today there was nobody in the public, so it didn't matter, but typically there would be a public comment section before any vote. Now, typically, under the law, the public comment doesn't have to occur at the same time of the action item. It just has to occur at some time during the hearing of that. A good example would be during an ordinance. There's a first and a second reading. You could have public comment during the first reading. That's totally acceptable. Now, the practicality is most commissions or councils will allow public comment during the first and second reading. Any questions so far? I'm kind of burning through this stuff fast. You guys already know this stuff front and back. Talked about that. Talked about that. Penalties. One of the only times we've actually seen elected officials or board members go to jail besides fraud, taking bribes and kickbacks, is for violating sunshine law. And a good example of that is City of Sebastian. This is all public record, not our client. I think it was a brand new council. They decided to lock the doors of City Hall and hold an impromptu private meeting and vote on a city issue behind closed doors without the public, without notice. Lock the doors. They were criminally charged. It's a misdemeanor, second-degree misdemeanor. You think misdemeanor, no big deal. No big deal until you're charged with one. And I can tell you it is a big deal because you got to hire an attorney, you got to defend yourself. Obviously, it'll probably get kicked down to a lesser charge, but still, the harm it'll do to your reputation is not worth it. So please do not violate public records laws. Any decision you make at a meeting that doesn't follow the public records laws is null and void. So it has no force or effect. So that decision they made down in Sebastian Inlet behind closed doors, no good. Any questions on sunshine? Florida in the sunshine. All right, public records. Okay, so the public has a right of access to all records of the state and local governments, as well as private entities acting on their behalf. What are private entities acting on their behalf? Contractors, vendors, that type of thing. Any documents that you create is a public record and is open for public inspection. Public has a right of access under the Florida Constitution unless there are exceptions. There are lots of exceptions. Under Florida Statute 119, it defines public records to, and it goes down the line. It's basically anything and everything you could possibly create. Includes audio, written, text messages, emails, any means of transmitting information is public record. Even drafts, doesn't have to be final form. So for staff, your draft documents, it's not uncommon for staff to have first, second, third, fourth, fifth, you name it, drafts of ordinances, contracts, even the drafts are public records, so they don't have to be in final form. There is no exception. There are lots of exceptions for public records, things like police officers, names, pictures, addresses, phone numbers, including their family members. That's exempt from public records. Medical records are exempt from public records. Code enforcement officers' information is exempt from public records. Security plans for like police emergency evacuation plans they have, like during special events or hurricanes, those types of things. Infrastructure plans that show detailed plans to how to get in and out of public buildings. Some of that stuff is exempt from public records. There is no exemption for, it's really embarrassing. This comes up often where there is something very, very embarrassing. It's usually in staff's emails, something they write between one another. People say terrible things in emails to each other. But so everything you write, I would write it with the lens that this may end up in the news or before a judge. If you write everything that you write with those two things in mind, you'll keep everything you write clean, simple, to the point. Most of your emails or text should be things like, hey, are you available for a call? Or it should be short to the point. You shouldn't really put a lot of substance in your emails and texts. That's my recommendation to you, city attorney. Use emails and text sparingly. The really embarrassing thing is passing notes. We have had an instance, and we always give this example. This happened to Wade Rose, who's one of the managing partners at my firm. Two of the commission members were passing Post-it notes during a meeting. One on the Post-it note, there was something derogatory about someone sitting in the front row who was an applicant or something on one of the items. And it said something like, can you believe how stupid she is, or something like that. It was just something that shouldn't have been said, but it was. And it was written down. The person who saw it, who it was written about, saw the note being passed and immediately stood up and said, I want to see that. That's a public record. I'm doing a public records request. I have a right to see it. She's right. She has a right to see it. And the law says you have a reasonable amount of time to produce the public record. What is a reasonable amount of time? That is however long it takes staff to obtain the record, review it for confidential information, and to provide the record. Now, if someone asks for any and all records related to the building of this building, that could take 30, 45, 60 days to get all those records. If a lady at the front row says, I want to see a copy of that note, a reasonable time is the city attorney takes the note, looks at it, reads it, nothing exempt here. It's public record, here you go. That's, and it turned out well. Just saw that note. So be very cautious about passing notes and creating public records. And again, no exception for really embarrassing. Emails we've talked about. Facebook social media page, that's also public record. We deal with that a lot. Actually, we've dealt with that here with the city of Daytona Beach Shores. Their Facebook page is a public record. So you can't, so inevitably, the city post, you know, be sure to come to the Memorial Day Parade this Saturday. Just a germane post like that. And sure as day, the very first comment is, city's corrupt, mayor's corrupt, the whole city's taking money for taking bribe. You know, it's just something awful. But unfortunately, you can't remove those comments. It's First Amendment protected free speech. It's a public record. You can't destroy it. Protected under the First Amendment. You have to leave it in there. The Facebook page is a public record. In Tallahassee, there's a division of library services. I believe that's the name of the agency, but they have a retention schedule that says you have to keep certain records for a certain amount of time. Certain records have to be kept for 5 years, 10 years, whatever. Facebook pages, I think there's I can't recall, but I think it's maybe, I may be totally wrong, but you have to keep that Facebook page up for a certain amount of time. So it applies to social media. So anything you put on your personal email pages that has to do with public business could be considered a public record. So be aware of that. Anything you text on your personal phone, if you text public business on your personal phone, that particular text is a public record. That doesn't mean everything in your phone is now open to public inspection, but that one particular text you will have to provide. Again, that doesn't mean that they get total carte blanche access to all of your texts and all of your kids' pictures and vacation pictures. They don't get all that. They get that one text or that one email that you send. But just be aware, public records also apply to your private devices. We've gone through that. You can sue. The penalty for not providing a public record is civil action. So remember I talked about First Amendment auditors? The scam used to be public records. That used to be the scam. And what they would do is they would go to a large agency in Tallahassee like DVPR, if any of you have ever heard of Department of Business Professional Regulation. It's like 3,000 or 4,000 employees. They regulate over 1 million people. They have a call center that has 200 or 300 people that work at the call center. They call the call center. The poor, 18-year-old college kid answers the phone. They say, "I'd like all the chief of staff's calendar events from 2024." And the poor lady that answers, or the poor kid that answers the phone is like, "What are you talking about? Chief of staff? I don't even know what's the chief of staff. I work at a call center. Can I transfer you something?" So, but anyway, they used to do that, or they used to go to the guy who's mowing the grass in the front lawn, and they would hand the guy mowing the grass in the front lawn the same request. "I'd like the chief of staff's calendar events for all of 2024. And the guy mowing the grass, what do you think he's going to do with that? He's going to ball it up, throw it on the ground, and run it over with a lawnmower. He's not going to know what to do with that. And people, and what they would do is they would go around to every state agency, go to the lowest person don't mean that in a demeaning way, the lowest position they could find, and ask for a big public records request. And of course it would get ignored, and then they would have a right to sue the agency. And it was an industry for a while. Attorneys were involved. They would just make hand over fist, money hand over fist, and you get attorney fees too. So the legislature put a stop to that scam by saying that before you sue an agency for not giving public records, you have to put the clerk of that agency on 5 days' notice before you sue them. So that you actually have to find the right person, in this case it would be Sherry, and give her 5 days' notice that if you don't give these records in 5 days, I will sue you. That put an end to all of that nonsense. Unfortunately, the legislature can't fix the auditor problem because that's a constitutional problem. So they could fix this, and they did. But there still is a penalty if after all that, the agency still doesn't provide a public record, they can still sue and get civil damages. It's also a crime if you intentionally violate it. It's a first-degree misdemeanor. It's the lowest level of crime. But again, I think misdemeanor is not a big deal, but get charged with a misdemeanor, and I think you realize it isn't kind of a big deal. But have to defend yourself. It would do more harm to your reputation than anything else. Okay, so that is public records. Any questions on public records? Am I going too fast, too slow?
No, if you have any questions, we just ask Sherry.
Microwave it.
I'll text you.
Microwave it.
So this is a pretty straightforward voting conflicts. It applies anybody who holds office. You can't do anything to benefit yourself. That's kind of everything you need to know about voting conflicts. You can't benefit yourself, a principal that you work with, a parent, a relative, or a business associate. So the key is it would ignore personal or private gain or loss, insider stock trading type stuff. So any kind of zoning thing that comes before you, you can't rezone a property knowing that you're getting ready to buy it. That's going to increase the value of the property. I mean, we have seen that. This what defines what a principal is. I'm not going to waste your time with that, but that's, the employer, things like that. Somebody that you work for, who's a relative. This is common sense. It's pretty close here. Father, mother, son, daughter. In the anti-nepotism and gift laws, the definition of relative is much, much broader. It goes to like second cousins and all that. But this really is your nuclear family and your close business partners. What is a business associate? Or, as a business associate is a business partner, anybody you do business with. Private gain or loss, that is one of the keys. Can't gain or lose money. I'm not going to bore you with the affected class, except to say that just because you're a member, just because you live in the neighborhood, doesn't mean it's a voting conflict to vote on an item that comes up in your neighborhood. The class is too big, so that doesn't count. So if you live in a subdivision or a condominium and an item comes up that deals with your condominium, you're not conflicted out from voting. You can still vote. Unless you have a pecuniary gain or loss that's very specific, that can be identifiable. I'm going to go through all this. So what do you do if you have a voting conflict? Number one, you abstain from voting. Number two, you disclose the conflict prior to the vote. And number three, you file a form with Sherry within 15 days. She has those forms. She probably has them with her. Also, you must disclose the conflict before participating in discussion of the matter. Actually, there's case law that says if you have a conflict, you're prohibited not only from voting, you're also prohibited from deliberating. So keep that in mind. So I would be extremely cautious. If you do have a conflict, I wouldn't even deliberate. I wouldn't take part in the discussion or the vote at all. I would just maybe leave the room. Some council members do silly things like they turn their chair around, or they, now's the time to take a bathroom break or something like that. I recommend not taking part in deliberation or voting. We talked about that. Quasi-judicial hearing, anything on voting conflicts? That's pretty straightforward. Just don't do anything that you could gain or lose money. Don't do anything corrupt. That's it. Don't do corrupt stuff. That's basically the gist of that. Quasi-judicial hearings. We had one today. Those are the types of hearings that we have. So basically, there are two types of local government actions. There's legislative action, which affects everybody in the city, and there's quasi-judicial actions, which affects a small group or an individual, usually an applicant. Quasi-judicial hearings are similar to court proceedings, but the rules of evidence are relaxed. You see that we go down the line and ask for voting conflicts. Everybody is sworn in. The person has a right, has due process. That means they have to receive notice. They have to have a chance to appear, to present evidence, to give testimony. There has to be public comment, and there has to be a record of the meeting kept, and they have a right to appeal the decision. Quasi-judicial hearings, your decisions must be based on three things. It has to apply. Number one, there has to be process, meaning the person has to have notice. That's never an issue because generally the person always gets notice, knock on wood. Number two, you have to apply the right law. That's never an issue. Even if you apply the right law incorrectly, courts will uphold your decision. So as long as you're applying your variance code to a variance request, a court will generally uphold your decision, even if you apply the law incorrectly. The big one is competent substantial evidence. You have to base your decision on competent and substantial evidence in the record. So what is competent substantial evidence? Competent substantial evidence is quantifiable facts, things that are not speculative. Things like staff reports are competent substantial evidence. Expert testimony is competent substantial evidence. Public comment from angry neighbors, that's not competent substantial evidence. Realize the mob mentality is not competent substantial evidence. Because you have a room full of angry people, please don't let that sway your vote. That doesn't necessarily mean that the entire city feels the same way that the 10 or 15 people in this room feel. It may feel that the whole city is up in arms, but really the reality is there's only 10 or 15 angry people. That doesn't mean that the entire city feels the way those 10 or 15 people do. So don't let mob mentality rule your or persuade you. That's easier said than done. Layperson public comment is not competent substantial evidence. Things like, this development is going to flood my road. The traffic is going to be bad. That's not competent substantial evidence. A traffic engineer saying this will cause traffic problems, that's competent substantial evidence. Someone from the St. Johns River Water Management District saying this development will cause the area to flood, that is competent substantial evidence. Not a neighbor saying this development will flood my land. That's not competent substantial evidence. Do you have a question, sir? Yes, sir.
So So there has been times in which a neighbor is also an expert in a particular field, and the chairperson, if you correct me if I'm wrong, has the ability to ask for a background to determine whether or not that person is an expert in the field and thereby given competent substantial evidence. Is that true?
That is true. If one of the neighbors happens to be a civil engineer, and he gets up and he says, it's my expert opinion that this project will cause flooding or that the ingress egress is not proper here, that's substantial evidence if you I would establish on the record that he is an engineer and go through his qualifications and certify him as an expert. Yes, ma'am.
What if our engineer disagrees with him? I mean,
That's why-
been here
Or you have a
15 years.
public-
That's why you make the big bucks. Because you have to that's called battle of the engineers. And that's very common in the law, and you can always find engineers to whoever's, I'm trying to think of a delicate way to say that. Yes, ma'am.
Things like that have happened. I've been here 15 years. And I would say, okay, well, I appreciate your comments, and we will discuss it with our engineer and get back to you.
That's right.
Like that.
And remember, your decision has to be based on competent, substantial evidence.
Mhm.
The court doesn't make you place that burden on you that you have to pick which engineer is correct. As long as you pick an engineer and go with what he says, I would pick your engineer, that's competent, substantial evidence.
Or she says.
Or she says, I'm sorry.
My only question I always have about a quasi-judicial hearing is when we do not approve it, we have to give a specific reason why we're not approving it, or can we simply say no?
The record, on appeal, the record is always part of the appeal. And you have to cite with specificity what the reason for your denial is. So the city attorney will usually say, can you please tell me why you're denying this? And I would cite with specificity what the competent substantial evidence in the record is that leads you to deny the application. So point to page number 45, point to paragraph number of this, point to expert testimony of this person, point to all the above. So yes, please put on the record what your competent substantial evidence is that leads you to your decision. It's very common for there just to be a no vote with no explanation. That's very hard to defend on appeal. Yes, sir.
Just a question. Two expert opinions, and they don't agree, city attorney, city engineer, and person that comes from the audience. Can the meeting be postponed, or like if you can't make a decision, or is it just a yes or no vote has to happen?
The meeting can be postponed at the will of the board. If the board feels like they need more time or more evidence, there could be a motion to table it or a motion to continue it. You have a duty to vote on every item before you, and that vote could be to continue. So yes, you can. But realize when you do continue things, there are people on the other side that are being affected. There are applicants that are waiting for the application, or paying for attorneys, or paying for engineers, or waiting for their house to be built. So just be aware of what the effect of that continuance is. This board only meets once a month. So if you continue it, that means that that person has to wait at least another month to get his shed built, or his addition built, or his project built. So there are ramifications, but yes, you can ask for it.
And most of the time, we're the first hearing, so there's a couple of hearings after that.
Most of the time,
Yeah.
you're one of 2 or 3 hearings. There are some exceptions that you are one and done, that you are the final say, and that would be for
Variances, special exceptions.
special exceptions and variances, you are the sole arbiter, so it stops with you. It can be appealed to the commission. That's the next step, but you have final order for it. Today was an example, one of the first item was the annexation ordinance. You're the first stop, there's 2 more stops, there's a first and second reading of the commission. So that's going on for 2 more. I think so, the second part.
Both the rezone and the flume will go before the city commission twice.
Mhm.
So both of those ordinances, so you were the first of 3 stops on both of those ordinances today.
I got a question. Something detailed and intricate understanding of that. Would that allow us to discuss amongst the board members, or would that fall into the sunshine law?
In a public meeting, while the meeting is in progress, you're free to discuss the matter all that you'd like. But if you're asking if you could all meet at the coffee shop after the meeting, talk it out,
That's why a lot of times when there's any questions or concerns, please bring it up.
Now, you can have special meetings, you can have workshops, there's any number of ways, if you feel like you don't have enough time to discuss it, there's any number of ways you can continue it to the next meeting. You can ask the staff to provide more information.
And there's a copy of all this, when I first did this, we had a book, of all of this in the book. Yeah, and
I think we may still have stuff, I'm going to put Sherry on the spot, but there is some information. But if you could email my firm, or you could email me directly if you ever have any questions, if you ever, need. There's a very valuable resource online. It's called Florida Sunshine Manual. The Attorney General puts it out every year. If you just Google Florida Sunshine Manual, it's like a 300-page document. It's keyword searchable. It's all about everything you need to know, all the law, everything about public records and sunshine law is in that document. And it's free. You can download it online. I advise you to do it. Save it on your desktop. Again, it's keyword searchable. So search police officer. You'll find everything. That's just a police officer. Just real quick, today's hearing, you saw 2 examples of 2 types of hearings. First was the legislative hearing. That was the annexation. That's a legislative issue. The Florida legislature has said that annexations are legislative issues because they affect the entire city. You're bringing a property into the city. That's legislative. Second one was quasi-judicial. Totally different standard. That's why we did the ex parte communications. That's why we swore in the witnesses. That's why we did the second one as a quasi-judicial. Right. Any more questions about quasi-judicial hearings? Look at that last slide. Any questions? How long did that was? 25 minutes, right?
Very nicely done.
Thank you.
thank you.
Again, if you have any individual questions, I think you all have my cell phone, or if you don't, Sherry can give it to you. I'm available 24/7 by email or phone, so please contact me. I'll keep you out of trouble. Contact me before you do it, not after you do it.
Absolutely.
Thank you.
That's it. Thank you. It was a pleasure.
Thank you.
Thank you very much. So having said that, is there any other questions or concerns so I can adjourn the meeting?
Happy Easter.
Oh, yes. Happy Easter and Passover.
Yeah, thank you.
All right, Harry?
Thank you.